Good afternoon. Welcome to the second lecture for week 12. This lecture is focusing on the questions of immigration and citizenship. So we're going to describe the immigration and naturalization process, kind of talk about the history of immigration restrictions and regulation in the United States, as well as look a little bit about the politics of immigration today. So the 14th Amendment of the Constitution states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So this includes certain rights to live and work, enter and leave, vote, stand for office, apply for federal employment, and various duties such as jury duty, participation in the military in the case of a draft, paying your taxes, enrolling in the census. The United States has what is known as birthright citizenship, that all persons born in the United States and the territories of the United States, except for children of wartime enemies or foreign diplomats, are soldiers. So if this is the idea of that if you are born in the United States, no matter who your parents are, you are a citizen. Also, if you are born to parents of, if you're born to U.S. citizens, if your parents are U.S. citizens while living abroad, you are also a citizen. There are some exceptions and exclusions here, but the idea here is that you can either be, there's two kind of paths here. You can be a citizen either by the location of your birth or your parents. Either way, you are a citizen by birth. The other process is through naturalization. There are a series of requirements. You must first be a legal permanent resident. You must have a green card. You must be in residence for 5 years or 3 years and married to a United States citizen with limited overseas travel. You should have a basic knowledge of English and civics. You have to pass the citizenship exam. You have to be in good moral character, and we'll talk about this a little bit later. Some of the restrictions on immigration kind of turn on this idea of good moral character, but the idea generally here is that you're not a felon, you're not a criminal, etc., etc. You have to be able and willing to serve in the armed services or civilian duties should you be called upon to do so, and you have to take the oath of citizenship in which you say that you will support and defend the Constitution. So those are the requirements to become a naturalized citizen. And the process is you submit your application with proof of eligibility and you pay a fee. You go through a biometric proof of identity screening. You conduct a naturalization interview with an immigration official to determine that you're not trying to cheat the system with all of the scare quotes that phrase should imply, especially for if you are a spouse to a citizen. They verify. I've had friends go through this process. They verify your entire relationship. So you come with photos of your first date, of your wedding, of you have testimonies of friends that have seen you together as a married couple, etc. It's a whole thing. And then you take the oath of citizenship and you surrender your green card. You can find more information at the USCIS, Customs and Immigration Services website here on the naturalization process. Now, this has been the history of immigration restrictions and regulations in the country is a kind of political history. In Article 1, Section 8 of the Constitution, Congress is given the enumerated power to establish a uniform rule of naturalization. That this uniform rule of naturalization then is the idea that everyone should have to follow through the same process of naturalization. And this is gives an implied power to regulate immigration. This really didn't become a whole thing until the early 20th century, late 19th century, early 20th century, with debates over mostly in the Chinese Exclusion Act, the Xi Jinping versus the United States and the Chinese exclusion cases established what is known as the plenary powers doctrine, that the political branches of the United States should be deferred to with respect to regulating immigration, that the court was basically going to defer to the president and to the Congress to determine the regulation of immigration. And this ruling set the doctrine that immigration is an inherent power of government and it's outside of normal constitutional review. That basically Congress and the president can do whatever they want to regulate immigration, that the Constitution doesn't really have a lot of say here. And you're reading from Nye. The court considered this necessary to protect the nation from foreign invasion, whether from armies during wartime or from foreign migrants during peacetime. The doctrine of plenary power privileged the nation's sovereignty absolutely over the rights of individual persons. Thus, the court declared that aliens have no right to be in and remain in this country except by license, permissions, and sufferance of Congress. So the plenary powers decision doctrines in the Xi Jinping and the Chinese Exclusion Act cases established the kind of presumption that in the favor of the US government, that you do not have a presumption of the right to immigrate, that you are allowed to immigrate into the United States by the generosity and by the deference of the United States federal government, that you don't have a guaranteed right to immigrate, that this is something that is, given to you by the government. So prior to the 20th century, the Naturalization Act of 1790 limited naturalization to free white persons. This was later expanded to include blacks in the 1860s and Asians only in the 1950s. This made the United States an outlier, since laws that made racial distinctions were uncommon in the world in the 18th century. In the early years in the United States, immigration was fewer than 8,000 people a year, including French refugees from the revolt of enslaved persons in Haiti. After 1820, it gradually increased, and between 1836 and 1914, over 30 million Europeans migrated to the United States. In 1875, we have the Page Act, which was the first formal immigration law. It was named after its sponsor, Representative Horace F. Page, who introduced the law to, quote, end the danger of cheap Chinese labor and immoral Chinese women. The law technically barred immigrants considered, quote, undesirable, defining this as a person from East Asia who was coming to the United States to be a forced laborer, any East Asian women who were engaged in prostitution, and all people considered to be convicts in their own country. That this was targeted specifically at East Asian immigrants, precisely on this question of moral character. It basically asserted that you were either a prostitute or an indentured servant coming to the United States. This began this kind of sexual policing of immigration. We see this kind of today with this question of these debates over birthright citizenship and the rights of children of immigrants, and the kind of like, oh, if we let people into this country, they're going to have children here. This kind of debate over this racial paranoia over declining birth rates amongst white native-born, citizens in the United States of European descent, all kind of have this prehistory and these targets at East Asian immigrants. This became much more formalized in the Chinese Exclusion Act of 1882 that was signed by President Chester A. Arthur, and it prohibited the immigration of all Chinese laborers. It basically prevented all members of a specific ethnic group or national group from immigrating. And this was pretty much a strict blanket of any Chinese persons immigrating to the United States, with exceptions for diplomats, teachers, students, merchants, and travelers. These laws were widely evaded. Immigration laws are always kind of widely evaded, but this was a huge ban. This was like a prohibition on any immigration. In the 20th century, the Immigration Act of 1924 set a total immigration quota of 165,000 for people for countries outside of the Western Hemisphere, which was an 80% reduction. Quotas for specific countries were based on 2% of the US population from that country as recorded in 1890. And so what this ended up doing is, if there were already large numbers of people of, of European descent in the country, that more people were able to immigrate from those areas, from those countries, right? If there are lots of Germans and lots of French and lots of Englishmen in the United States already, that quota of 2% is going to be higher for them for subsequent immigration. This also expanded the enforcement capacity of immigration services, established the Border Patrol, and created the possibility of, the possibility of deportation. And as you're reading from that, I suggest that this act of 1924 created this legal category of the undocumented immigrant, this idea that someone had immigrated without going through this formal process, is not part of this under this formal quota, not this formal process. And the backlash against this bill and this created this discourse between the deserving and the undeserving immigrant, that this bill created these kind of two discursive categories that we have between the good immigrant who follows the law and the undeserving immigrant who did things the wrong way, again, with all the scare quotes that those phrases should imply. This act was updated in 1965 with the Immigration and Nationality, not Naturalization Act. That is a typo. Nationality Act of 1965. And this act replaced the national quotas with a set of 7 immigration categories. It eliminated a national origin, race, and ancestry as a basis of immigration. It preserved the per country and total caps, but it did exempt family members from those caps. It created a 7-category preference system that gave priorities to both relatives of United States citizens and people with professional and other and employable skills. And it created limits for immigration from the Western Hemisphere. So we have this shift in where previous immigration restrictions were prohibitions of people not from the Western Hemisphere. This has shifted towards restricting immigration from those within the Western Hemisphere, targeting Latin and South America. And this is the first time that prohibitions of immigration, restrictions on people from the Western Hemisphere, was put into law. And the 1965 INA still governs the legal architecture of immigration today. Let's break down those existing restrictions. We can get rid of that, sorry. There are both quantitative and qualitative restrictions on immigration. Quantitatively, there are a total cap of 675,000 annually permanent immigrant visas available for people to become legal permanent residents in the United States that are divided into various categories. I'll talk about those in a little bit. Visas for spouses, unmarried minor children, and parents are not included. This is the idea of family immigration that is not governed here. There's also a 7% per country cap that no more than 7% of that total visas can be from any one country. So no group of permanent immigrants, family-based and employment-based immigrants from a single country can exceed 7% of the total number of people immigrating to the United States in that year. There are also qualitative immigration. Section 8 of the INA includes a series of exclusions, including you can be restricted from immigration based on your health, based on criminal convictions, moral turpitude, and controlled substances violations. If you are a terrorist, a communist, or a totalitarian, you can be excluded from the immigration. If you are likely at any time to become a public charge, this became much more prominent in political discourse when the Trump administration expanded what it meant to be a public charge. We'll talk about that in a little bit. If you are an unskilled laborer, if you're present without admission or parole, so if you are in the country without if you're an undocumented immigrant currently in the country, you cannot, without leaving the country and applying for formal immigration status, you cannot just become gain a green card. You cannot become a legal permanent resident. If you lack certain documents, if you are ineligible to become a citizen for whatever reason, if you were previously deported from the country, you cannot be a citizen, and there are other criteria, including prohibitions against polygamists and child trafficking. Now, there are lots of different types of visas. There are the family visas. Whether you're the spouse of the citizen, family member of the citizen, or the family member of a legal permanent resident. These are pretty expansive. Then there are a series of employment visas. There are EB-1 visas, which are persons of extraordinary ability. There are EB-2 visas, are good visas to those with advanced degrees, EB-3 to college degrees. EB4 are special immigrant visas. EB5 visas are those who are who are going to basically bring a lot of money to the country and make investments of up to $1 million and employ 10 full-time US workers. And then there are special visas categories, these SIV and SQ visas that were given to Iraqis and Afghanis who supported the US government during the wars in Iraq and Afghanistan. These are very small numbers of visas here. And then there's the diversity visa lottery, that these are allocated randomly to nationals from countries that have sent fewer than 50,000 immigrants to the United States in the previous 5 years. These are known as diversity visas, with the idea that we are going to diversify the immigrant pool, because most of the visas go to family members, or they go to people with advanced degrees and with at least college degrees, right? So it's actually very difficult if you do not have an advanced degree, if you do not have a family member in the United States, to get an immigrant visa to the United States. It's also important to distinguish between immigrants and refugees or asylees. Refugee is a person outside his or her country of origin who is unable or unwilling to return to their country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. Refugees are then required to apply for a legal permanent resident status 1 year after being admitted as refugees. Asylee is a person who meets the definition of a refugee and is already present in the United States or seeking admission in a port of entry. Asylees may apply for green card status 1 year after the grant of asylum. Now, there are also quantitative and qualitative restrictions on these. In 2019, the number of refugees admitted to the United States was capped at 30,000. There are also regional limits. And there are also qualitative restrictions based on determining what this well-founded fear is. That this is limited to race, membership, in particular social group, political opinion, religion, or national origin. How this particular social group is the key category here gets interpreted is up to immigration officials. And you have to go through what's known as a credible threat interview, in which a judge determines whether or not you do actually have a well-founded fear of persecution. So it's not a guarantee just because you petition for asylum. Immigration federalism, also there, while it is the exclusive domain of the federal government, there has been kind of moving back and forth of immigration politics at the state and local level. There have been increasing restrictions since September 11th. In Arizona, they famously passed SB 1070, the Show Me Your Papers law that allowed law enforcement officials to basically demand any person on the street to prove that they have legal status to be there, which kind of highlighted during the Obama administration kind of contestation between the state and the federal government over how lax or strict immigration restrictions should be. There also is significant debate and variation between states on how strictly E-Verify is enforced. The verification process to prove that people have the right to work in the United States based on their immigration status. On the question of sanctuary cities and sanctuary states, and in question of in-state tuition for state colleges for undocumented students, but there's also been various loosening of restrictions. These are kind of summarized in many ways by the California package, which expanded membership rights even without formal immigration status to undocumented immigrants, including the right to get a driver's license, in-state tuition for colleges and universities. Now, a lot of the Trump administration focused on a lot of policies that gained notoriety focused on immigration. One of his first acts as president was to issue Executive Order 13769, known as the travel ban, that listed the countries of Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. That was then expanded to include Nigeria, Eritrea, Tanzania, Sudan, Kyrgyzstan, and Myanmar, that basically restricted immigration and travel from those countries. The Supreme Court upheld the travel ban in Trump versus Hawaii. The travel ban does not violate the Establishment Clause or exceed executive authority. There's in the summer of 2000, 17 in 2018 is summer 2018, sorry, the announcement of the zero tolerance policy, the immediately deporting individuals for illegal entry into the United States, separating families from children and not allowing for asylum claims to be heard. This is the infamous kids in cages kind of policy. This was eventually rolled back over public pressure. The Trump administration also issued in 2018 a historic low refugee cap of 18,000. And in August of 2019, that went into effect in 2020, it expanded the interpretation of the public charge restriction in the INA to not just include cash benefits, but basically if you ever were to apply for any form of public assistance, including food stamps for your children, that would count as public charge and you would be ineligible to become a legal permanent resident. The Biden administration has recently announced that they are not going to be, that they are no longer going to be implementing this interpretation of the public charge rule. But that does not mean that the Biden administration has been the exact opposite of the Trump administration on immigration. But in January, President Biden proposed sweeping immigration reform, including a path to citizenship for the millions of undocumented immigrants currently in the country. He initially proposed a 100-day moratorium on deportations, but that has been indefinitely blocked by a federal judge, indicating that that would violate the Administrative Procedures Act. More recently, the increasing number of unaccompanied minors seeking entry at the southern border due to Biden's announced policy change on not immediately deporting children, migrant children, has led to the surge of unaccompanied minors seeking entry under the Biden administration. However, that is not translated to opening the doors to unaccompanied immigrant children, and many, as the Biden administration has had to reopen emergency shelters and detention facilities for migrant children because it cannot hold, because of both COVID restrictions and laws prohibiting holding children in formal DHS detention centers. Has had to create these emergency, basically tent cities to hold immigrant children until their cases are heard and their status can be determined. So they're still holding children, immigrant children, in camps at the border. So next week, we are going to talk about civil rights. We're going to talk about African-American civil rights from abolition to Black Lives Matter, women's suffrage and liberation, and also looking at some struggles for civil rights from Indigenous, Latinx, and queer folk in the United States. In addition to the chapter from the textbook, I'd also like you to read a couple of primary sources and some other kind of readings on civil rights here. The minute paper question for this week, again, you can go to bit.ly/Pauls101MP. Respond and react to "Na is the strange career of the illegal alien." What did you learn from the article? Did anything surprise you or change the way you think? So that is it for this week's mini lectures. I will see you in discussion section. Take care.